Everyone. This is Steve Newcomb. I'm the co-founder and director of the Indigenous Law Institute, and I have been working on the study of the doctrine of discovery or as I prefer to call it, the doctrine of Christian discovery and domination for several decades. And I'm very pleased to be here on this Zoom broadcast with my friend Joe Heath, who's an amazing attorney because he's spent so much time investigating the origins of the doctrine as well. There aren't that many of us. So how are you doing today, Joe?
I'm very well, Steve. Thank you for
Great.
the kind words. I'm Joe Heath. I'm General Counsel for the Onondaga Nation. I'm speaking to you from about the center of the Onondaga ancestral homelands. And I've been a student of Steve's for those decades and still learning. So hopefully in this segment, we can share some of what we've learned and see if that's helpful to other folks.
So, Joe, can you go ahead and just explain in your straightforward manner how you understand the doctrine for anybody that might be watching this and not have that basic understanding?
Well, the doctrine is a construct that began in the 1400s. And it is based upon papal bulls, as you well know. And what it says is that when Christian nations of Europe go to non-Christian areas, first it was the Crusades, and then Africa, and then Turtle Island, if they discover non-Christian people, and they use some very, very pejorative terms other than that, infidels, pagans, heathens, then the title to the land immediately transfers to the Christian kings. That's who it was at the time. And so it treated the indigenous peoples as though they were flora and fauna. Basically, they had very, very limited rights. And I think the issue that you and I have spent so much time on is the problem that it's the centerpiece, the basis of U.S. Indian law, and we can get into that more.
As you say that, Joe, it occurs to me that the information we're talking about was in the mental world of those people in Europe, in Western Europe. In other words, there's this way in which English is spoken to say, well, this happened, that discovery gave them title, and so forth. And what really is going on there, in my view, is that they were thinking up these ideas and putting those ideas on paper. And now we're going back after the fact, looking through that historical record and looking at the evidence of what they thought and what they wrote. And so I think that's quite amazing that somehow these metaphorical notions, the use of metaphors, the use of ideas that they had a monopoly on because it was their language system. Our ancestors did not have access to that language, didn't speak the language, didn't read the language. And now all these centuries later, we're going back over that record and attempting to make meaning, making some sense of it in terms of what's been going on. So what's your response to that observation?
Well, I think the problem continues because when we go back and look at, most of my job is to look at what the courts have said. And the more we look at that, the less straightforward it is. And they just keep making up new excuses to continue what is really the principle, the foundation of colonialism. Because what they were doing in the 14th and 15th century is invading other lands, just as the Pope told them to, conquering them, and then subjugating all of the people. And today what they're doing is, rather than speaking directly where they say we have a right to enslave people, they use all these euphemisms, and we will get into that more in the sessions that we each prepare and as we go along today.
So euphemisms are nice sounding words for really terrible things. It's one way to understand it, right? that your understanding?
Yes, what really struck me is so about 6 weeks ago, you and I and Peter DeRico were taking a hard look at the McGirt case, and um, and we
McGirt versus Oklahoma. Yeah.
right, that's the July 9th decision by the Supreme Court in which Gorsuch ruled that because the Muskogee Reservation had not been terminated by Congress, that the state criminal law could not apply. Now, he doesn't use the word terminate. He uses the more clinical legal term disestablish. So that's one example of that problem. And then when we look at, and never in that decision does Gorsuch or even the snarky dissent by Chief Justice John Roberts, they never say the term plenary power. And yet that's the basis of the decision. If Congress had terminated that reservation on the claim that they can do that unilaterally, Gorsuch would have endorsed that in a moment. And so then we started to look at plenary power, and I know you know as much about that as anybody. So maybe you would take it from there a bit.
Well, yeah, the idea of plenary power, plenary meaning absolute, and the idea of having the power to legislate, to make decisions with regard to Native nations, and then looking at where Congress might have obtained that power and or not, and simply purported to have it and acting upon that assumption, right? So when we look at this idea of plenary power, where is that in the constitutional framework that's supposed to give rise to any authorized or legitimate exercise of authority or power by Congress? You don't find it in the Constitution. And what you find is the Commerce Clause, and Congress shall have the power to regulate commerce with foreign nations, among the several states, and with the Indian tribes. And Mark Savage, an amazing attorney out of San Francisco, wrote 2 brilliant law review articles in the early 1990s, 1991 and 1993. And one is called Native Americans and the Constitution, the Original Understanding. And he demonstrates in there, by looking at the record of the founding of the United States and the constitutional conventions, that James Monroe put forward the idea that Congress shall have the power to regulate all Indian affairs, which would match the language that had been in the Articles of Confederation. And they declined to put that into the Constitution, and instead limited that to the power to regulate commerce with the Indian tribes. And so, in my view, the way in which Congress has exercised whatever supposed authority it has been premised upon an assumption that it has a legitimate constitutional basis for doing so. But when you really trace it back, what you find is that it's in the basis for that is in the Johnson versus McIntosh decision of 1823, and the idea that Native nations are somehow subject to the ultimate dominion of the United States. And when you take that letter N and you remove it from the end of the word dominion, you get dominio, which is a Latin word meaning variously to dominate, to subjugate, to subdue, to subordinate. And so that's the theme of domination that's woven all through that Johnson versus McIntosh ruling that's traced back to those Vatican documents that you mentioned initially. So that's the framework. And what I found amazing is that Gorsuch included the doctrine in the decision, McGirt versus Oklahoma, but declined to make it explicit, just as they did not mention plenary power. They did not mention doctrine of discovery, but they put that into the decision covertly through a property law treatise by Emery Washburn. And of course, Peter DeRico, my good friend and man with a Yale law degree and a professor of legal studies for more than 25 years, he did the research to find that property law treatise, and he found that here is the idea of Christian nations, discovery, Johnson versus McIntosh. It's all there in the decision, but covert and hidden through that treatise. So that's my understanding of plenary power in this conversation.
And you're absolutely right. There's no basis for it in the Constitution, because what Gorsuch writes and all of these other cases that we've been discussing is that they claim that Congress can break any treaty it wants at will, and that even the courts can't review that. So that's the ultimate dominion, absolute power that plenary power means. And they don't, how do you square that with the provision in the Constitution, Article 6, that says treaties are the supreme law of the land? And to show you how blatantly unconstitutional this is, I can't believe I'm about to quote Justice Clarence Thomas, but as we know, he has written 3 or 4 dissents, maybe more, or separate opinions, I should say. And the most recent in 2016, where Thomas joined with the majority in a concurring opinion, but he states categorically, and he repeats because he's said this 3 or 4 times previously, there is no basis in the Constitution for plenary power. He doesn't change the result of the case, which is what he should have done. But the fact that somebody who we all know is so non-progressive would understand that constitutional lack of authority for plenary power, I think is very telling. I don't know why the other strict constructionist, which is an abused term in legal scholarship, I think, why he's not joined with other people. Which brings me to the thought that we could discuss a little bit that perhaps the Supreme Court is a less hostile environment for indigenous people than it was in 2005 when they issued the Sherrill decision. We now have Gorsuch, who has, I think, changed the makeup of the court, at least as it comes to treaty rights. And this is the 3rd opinion in the 2 terms he's been there, where he's joined the 4 liberals on the court to make a 5-4 majority. And in each of those decisions, one was the Herrera versus Wyoming, a hunting rights case, which could easily have gone against the indigenous people years ago, where they ruled that a treaty protected an indigenous hunter. And the second was the Cougar Den case, as you know, with the Yakama Nation in Washington, where the issue there was a gasoline tax. And again, they ruled that a treaty which did not have, obviously didn't have a specific reference to a gasoline tax in the 1850s, but they ruled that the provisions of that treaty, which guaranteed free travel, that protected the nation from the tax. So the point really is that we now have a different court than we did when Justice Ruth Bader Ginsburg authored the Sherrill decision in 2005. And as you know, that's the decision that says if your treaties are old and they might upset the settlers, you lose. But the point really is that plenary power is illegal. It's clearly a violation of international law. And as you know, it is fundamentally in violation of the principle of free, prior, and informed consent. And so it's not constitutional. And yet that's why indigenous people are treated so horribly in our courts.
The use of the phrase ultimate dominion in the Johnson versus McIntosh ruling and Marshall's statement that the nations of Europe had assumed the ultimate dominion to be in themselves and claimed and exercised as a consequence of that ultimate dominion power to grant the soil while in the possession of the natives. And paraphrasing a little bit there, but the basic gist of it is that this theme of ultimate dominion, this claim of a right of domination, is the foundational underpinning of all of these decisions. And it's the result is a framework that has been genocidal toward Native nations and peoples, in my view, and has worked toward the elimination of Native nations. And I think that the McGirt decision is quite amazing, as I stated in a prior recording of one of these conversations, that both the majority and the minority in that case were looking at all the ways in which Congress had acted toward the elimination of the Creek Nation. And of course, genocide is the intention to destroy a nation or people in whole or in part. And so that you see that record, historical record that they go through, and the minorities simply saying, yep, that has been accomplished by Congress, and the majority saying, well, no, not quite, not yet. There's still some way to go. And so is that your understanding as well?
Yes. The way I describe McGirt is the debate between Gorsuch's majority opinion and Chief Judge John Roberts' minority opinion is they're arguing over what are the real rules for how we properly break Indian treaties. That's what it is. And out of that discussion comes a reaffirmation that Congress could unilaterally terminate that reservation. And I hope folks have time to look at the comments that I'm going to make in the separately recorded session, where what plenary power really means, and we're probably close to out of time here, it means that the United States and Congress, upheld by the courts, claim that Congress can terminate any reservation that it wants. And when we really start to look at that, we see that hundreds of Indian nations were terminated in the late 50s and early 60s. That's what plenary power means. That's what U.S. Indian law means.
And so that severance of the relationship between the federal government and Native nations, or as they prefer to call it, Indian tribes, that's what you mean by termination, which began, if I'm not mistaken, as a policy in 1953. Is that correct?
Yes.
Yeah.
And Congress stated it boldly. Our policy is to terminate as many Indian nations as we can.
Yeah.
They went at it pretty, actually that Congress must have been a lot more effective than this one, because 109 nations were terminated in an 8-year period.
Yeah. And so the couple of things that occurred to me based on what you had just stated, and one of those is that the way in which this doctrine of discovery, the right of discovery, the right of dominion, the way in which that has been utilized by the United States has, generally speaking, been done out of focus. In other words, they don't really bring forward the fact that the federal Indian law system is, and through Johnson versus McIntosh, is based upon Vatican documents from the 15th century. They leave that out of focus. And so I think that's one of the most unique aspects of this whole historical record. And the fact that Joseph Story, in his commentaries on the Constitution, makes a direct linkage between a papal principle of domination, ac barbare nationes deprimantur, and barbarous nations be reduced or subjugated. And the Johnson versus McIntosh ruling is quite astounding. And with regard to strict construction, meaning the strict interpretation of the letter of the Constitution, those strict constructionists are fascinating to me because they ignore all this information. And why in the world would Joseph Story, as a sitting member of the U.S. Supreme Court, be referencing Latin language from a Vatican papal bull in his commentary on the Constitution of the United States, unless he understood that to be part of the backdrop and context for the Constitution of the United States?
Because we have to go back to the fact that Marshall and all of the so-called founding fathers were land speculators. And so Indian law is really about how do we get rid of Indians so we can seize the land, sell it for profit, or destroy it with our extractive industries that we've had. And it's about making money, and Indians are in the way. And so we've had all of these constructs for 220, 240 years to justify colonialism.
So the concluding thought that I wanted to forward is that Johnson versus McIntosh is considered to be the foundational case with regard to U.S. property law. And some people have referred to it as the cornerstone of U.S. property law, meaning the starting point or the most expressive way in which the court has understood and articulated the foundational principles of property law. When you take the notion of property that William Blackstone put forward to say that it is despotic dominion, which is a way of saying domination. And when you look at the property law textbook by Charles Monroe Haar and Lance Liebman, they refer to property as the first establishment of socially approved physical domination over some part of the natural world. So that is the real theme that is in play here. The claim of a right of domination, they use all kinds of euphemistic language to make it appear that that's not what's going on. And that's how they're asserting a right to the land as property, to the resources as property. And the result is trillions of dollars for what the Supreme Court on 2 different occasions has called the American Empire. One of those occasions being Loughborough versus Blake in 1820, and the other one in Downs versus Bidwell in 1901. So I really want to thank you for your time, Joe, and for this conversation. And I hope that folks will get something meaningful from this conversation. And thanks for all your hard work. I really do appreciate it.
Well, thank you for your patience in teaching. And as usual, it's just wonderful to exchange ideas with you. Thank you so much.
Thank you, Wanishi. Take care now.